In 1996, voters approved an amendment that eliminated from Section 180 of the Constitution language that authorized local governments to levy poll taxes. So now the local government couldn't levy poll taxes, which actually was a racist thing. But they did that in '96, which I'm not even sure why they was doing poll taxes. If you want to vote, you got to pay these taxes. And they also deleted language from Section 187 that provided for the maintenance of racially segregated schools. So Section 163 said common schools must be provided for everybody, and I guess Section 187 was they have to be racially segregated, blacks over here, whites over there, and that was, you know, fair under the eyes of the law. The 24th Amendment to the U.S. Constitution and several U.S. Supreme Court cases made this amendment symbolic. So the 24th Amendment to the Constitution and several U.S. Supreme Court cases made this amendment symbolic. So that means that there wasn't racially segregated schools anymore. It was 1996, but they was doing it just to kind of, you know, to clean up the language. Sort of in 76, why they passed 13th, 14th, and 15th Amendment, and also 1953 when they scratched male out of those who are allowed to be eligible to vote in the Constitution. So they're cleaning up the language that had been put in there for a long time, since it's 1891. You know, there was racist language, there was sexist language that's they had to kind of delete, you know, pretend this wasn't a part of the Constitution. It should just be rewritten. Document wasn't very flexible. It's a bunch of statutes, and that's why they keep on just butchering it, taking out a chunk here, putting in a chunk there. Okay, so in 2000, voters ratified an amendment that abolished the Railroad Commission. So the Railroad Commission, that was like one of the main fucking things that William Justice Goebel was able to put into 1891 Constitution, and now they're abolishing it, right? So they've been going after any type of, right, the L&N Railroad have had lobbyists. They've been trying to control Frankfurt from day one, just like King Coal controls Frankfurt. They're all a bunch of fucking corporate, you know, whores, bunch of paymasters to the fucking big industries. So they abolished the Railroad Commission. They rejected a similar amendment in 73. So in 1973, Kentucky voters were more, I guess, aware, because in 1988 they stopped strip mining, but then 12 years later they're sitting there banning the Railroad Commission. So now it's going to be hard as shit if your kid or somebody gets run over by the railroad company to be able to get some sort of payout for that. Especially if it's their fault, especially if you're a worker on the railroad company and something happens to you. Now there's less regulation for you know, a proper settlement or kickback from any type of mistake that they make. So amendment ratified 2002 modernized Section 190, which deals with corporations. So that'd be interesting to see that language of 2002. It says modernized Section 190. So let's see what Section 190 is. Okay, so it says corporations, regulation of corporations by the General Assembly. So remember, Section 3 is one of our Bill of Rights. We have a right to revoke any corporation's charter. That's Section 3. So we'll start that out. Section 90, corporations. Except as otherwise provided by the Constitution of Kentucky, the General Assembly shall, by general laws only, provide for the formation, organization, and regulation of corporations. Except as otherwise provided by the Constitution of Kentucky, the General Assembly shall also, by general laws only, prescribe the powers, rights, duties, and liabilities of corporations, and the powers, rights, duties, and liabilities of their officers and stockholders or members. So, Section 191 is repealed in 2002. Unexercised charters granted prior to Constitution revoked. Corporations restricted to charter authority holding the real estate limited. This doesn't look good, what they're repealing. They're repealing several sections. It's saying 2002, several sections were repealed. And so I guess the amendment in 2002 repeals corporations to have place of business and process agent in the state. Stock or bonds be issued only for money or for property or labor at market value. Watered stock void. Corporations restricted to charter authority holding of real estate limited. All this sounds like it might be okay, but I don't know. Section 190 is where corporations begins. And so corporations is a topic that is dealt with in detail in Kentucky's Constitution all the way to Section 208. So 190 to 208, but 208 was repealed. 207 was repealed. So cumulative voting for directors of corporations, proxies, so now they're allowed to vote for their own fucking people. Corporations include joint stock company or association. What is it? Why is Section 203 liabilities under corporate franchise not released by lease or alienation? Catch line at top of repeal. Foreign corporations not to be given privileges over domestic. What the fuck? How many? Section 200 is repealed. Catch line at time of repeal. Domestic corporation consolidating with foreign does not become foreign. So in 2002, you're gonna fucking delete half your Constitution about corporations when it was clearly an anti-corporation document. You want to restrict corporations. You want to be able to revoke their charter. You don't want corporations to run roughshod all over you. But the way our political system works, there's legalized bribery. So the corporations pay you a little bit of money. You get some oil money. You vote in lines with the oil company. They helped you finance your campaign. They got you to where you're at. They bought you. Or you could be like Teddy Roosevelt, and they'll buy you, but you just won't stay bought, and you'll do what you think is right anyways. So that was in 2002. So great fucking call, So Kentuckians in 2000 has just been fucking up. They was progressive minded in 1988 when you had Ronald Reagan and all the other people there. But in 2000, voters ratified an amendment, abolished the Railroad Commission. Right. So goodbye William Justice Goebel. Goodbye regulation of the railroad companies in case the railroad companies didn't have enough power already. Then in 2002, they said, all right, corporations, we're going to make a lot of these laws easier for you to deal with. We don't want to have so much red tape for you. And so they just shredded in the Section 190 in 2002. So Section 3 is still there. So thank God that's still there. They haven't taken away our Bill of Rights yet. But they are repealing other antiquated sections of concerned corporations. Antiquated sections that they determine to be antiquated. So they're for pro-railroad, doing whatever the fuck they want to do, running roughshod over them. So you got the transportation companies who's going to be running roughshod over Kentucky now, 2000, because of 2000. An amendment now, a 2002 amendment is going to have the corporations run roughshod over Kentucky. And then you have in 2004, now they're saying marriage between a man and a woman is the only way a marriage can be. And then, therefore, same-sex marriages are banned. So get the fuck out, all you gay people, right? It's codified language. Do you believe in, do you believe in marriage between one woman and one man? That's the language that you're using. It's a partnership between two individuals. I've seen very effeminate men and very manly women out there, and I've also seen very loving lesbian and gay couples out there too. So, the world needs more love. I bet two gay couples could actually, or lesbian or a gay couple could raise children better than a lot of these, fucking, raping, child beating, fucking wife beating, fucking shitty ass fucking husbands out there, right? So, yeah, so Kentucky's just fucking up. In the 2000s, Kentucky is just fucking up so fucking much. You've had Mitch McConnell for 30 years in office. They're fucking brain dead. They didn't give a shit. They haven't fought against any of this shit. They've been going along with the flow, and since Republicans, some of the fucking working class voters, Republicans talk like me, I'm a dumb fuck, right? And so they say, I guess faggots or whatever, they pro corporations. Corporations are people. Railroads are people too. Corporations are people, railroads are people, but not gay people. They're not people. The corporation's more of a person than a gay person is, and so is a railroad. There's a whole train, and with gay people, it's a different kind of train. I don't know. I'm trying to be them. I'm trying to be in their fucking position. So, moving along, right? So that's what they did in 2000. 2000, they abolished the Railroad Commission. 2002, modernized the corporate section 190, and then in 2004 said that homosexuals are illegal. And actually, there was a statute that they had passed that said sodomy they wasn't allowed to go after just gay sex if we weren't going to go after everybody's sex. So you couldn't just point out, butt sex for men was illegal, but butt sex for man and woman was not illegal. So they had actually struck that down. So that was a movement towards gay marriage. But now we went backwards in 2004. I proposed to legalize gay marriage at U of L with the student council, and Curtis Frizzell and Travis Galt and all the fucking Greek life at U of L, they didn't give a shit. They're like, who gives a shit? You know, we're basically here to kiss the fucking bosses' asses too. You know, that's all we're doing. We don't actually want to do anything like significant or substantial. Who gives a shit? We're not going to do that. So the amendment ratified in 2002 modernized Section 190, which deals with corporations, and repealed other antiquated sections that concerned corporations. In 2004, voters ratified an amendment that declared marriage to be between a man and a woman. I have read this so many times. The amendment also prohibited legal status identical or substantially similar to that of marriage for unmarried individuals. So they don't even want civil unions. In 2012, voters ratified an amendment declaring that citizens of Kentucky have the personal right to hunt, fish, and harvest wildlife, subject to conservation and preservation laws, and that public hunting and fishing shall be the preferred means of managing and controlling wildlife. So it's all about guns. We're allowed to hunt, fish, and harvest wildlife, and the way that we're going to manage and control wildlife will be through hunting, public hunting and fishing. 44 of the 263 original sections of the Constitution of 1891 have been amended, some more than once. 16 sections have been repealed and reenacted the judiciary sections by virtue of the Judicial Amendment of 1975. 34 sections have been repealed. One of these was revived, and 9 sections have been added. One of these bring among the 34 that have been repealed. These changes have considerably streamlined the document and achieved not a few of the reforms incorporated into the abortive Constitution of 1966. The judiciary also has adapted the Constitution to modern times by its liberal interpretation of certain potentially restrictive provisions of the state charter. For example, the Court of Appeals ruled in Matthews v. Allen, 360 SW2D 135, 1962, that cost of living adjustments based on the Consumer Price Index did not violate salary restrictions found in Section 246. Judicial interpretation of the Constitution. In the words of Robert F. Stevens, the late Chief Justice of the Kentucky Supreme Court, in recent years, the constitutions of the various states have become increasingly important in the jurisprudence of those states as tools in the practice of law. This growth has been given impetus by several decisions of the U.S. Supreme Court, which not only recognize the sovereignty of the states, but arguably encourage the use of those state constitutions. See, for example, Oregon v. Haas, 420 U.S. 714, 1989, and Michigan v. Long, 463 U.S. 1032, 1983. An examination of the leading constitutional opinions of the Kentucky Court of Appeals, the Supreme Court of Kentucky until 1975, and the Kentucky Supreme Court, created as the Supreme Court of Kentucky by the Judicial Amendment of 1975, provides evidence of this increased significance, as well as the overall importance of the Constitution and its practical meaning and application. The first 26 sections of the Kentucky Constitution constitute the Bill of Rights. The language of these sections were taken largely from the Pennsylvania Constitution of 1790, but borrowed some verbiage from the Declaration of Independence and the Virginia Declaration of Rights in 1776. Framers of the Third Constitution and the current Constitution add one section each. In the third section, Section 2, or in the third Constitution, they added Section 2, which denies absolute and arbitrary power. In the current Constitution, they added Section 25, which forbids slavery. So Section 2, Section 25 are actually kind of opposites of each other. But the first 26 sections, basically all of them except for 2 of them, came from the Constitution of Pennsylvania in 1790. So the Bill of Rights that was in, and it's not clear, there's no like Bill of Rights. You can't just look at the Pennsylvania Constitution and see Bill of Rights. It's a long-ass charter, and so I'm not for sure actually where the Bill of Rights even came from. So I'm sure one of the sections had the so-called Bill of Rights, but it wasn't the first section. So shit. And so that's something different, right? Framers of the third Constitution and the current Constitution add one section each. Section 2, Section 25, those are the 2 that were added. In the third Constitution, Section 2 is added. Fourth section, or the fourth Constitution, Section 25. So everything in the first 26 sections have been there, you know, nothing's changed. The framers of the third Constitution added subsections to Sections 1, authorizing the legislature to enact laws to prevent persons from carrying concealed weapons. So that's fascinating. Framers of the third Constitution added subsections to Section 1. So the third Constitution in 1850, you know, yeah, we got a right to bear arms, but it can't be concealed. We have to see them. And then 11, authorizing the legislature to enact a general change of venue law. And in 1988, voters ratified the a legislative addition to Section 19, in effect prohibiting strip mining under broad form deeds unless such mining is specifically agreed to by the parties of the deed. So that's fascinating, okay? It's fascinating that the third Constitution, the 1851 ones, the pro-slavery people were the ones that added the carried concealed. Yeah, you can carry a weapon around on you, but it's got to be, it can't be concealed. It has to be on your person. We have to see that you got a gun. So it's interesting. That actually would make you safer if you knew that the person has a gun, whereas someone concealing it.